in about 30 seconds. Here we go. Your Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to the Supreme Court docket. We welcome both counsel as well as those who are watching on our Supreme Court Live channel. I would now ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call this 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Monday, October 25th, 2021 consists of one case. Appeal number 120611, L. Ruth Fawcett Trust, Syndicate, Page Calmer Trustee, on behalf of itself and all others similarly situated, versus Oil Producers, Inc. of Kansas, case out of Seward County. Briefs both sides. This case is scheduled for 20 minutes on each side. The appellant, Ruth Fawcett Trust, has reserved 7 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Rex Sharp on behalf of plaintiff class, ready for argument.
Robert Kirkendall on behalf of defendant Oil Producers, Inc. of Kansas, ready for argument.
Thank you, counsel. Mr. Sharp, you may begin your argument.
Thank you. May it please the court. I'm Rex Sharp on behalf of the plaintiff class of royalty owners. I will give a brief description of the case as it has come to the court. Raw gas won't burn efficiently, so well operators like OPIC hire midstream service providers to clean up the gas, clean up that raw gas using gathering, compression, dehydration, treatment, and processing to isolate the valuable gas products, which are methane, ethane, propane, butane, and pentane. OPIC deducted the cost of that midstream services, and the royalty owners sued to recover the cost. The royalty owner class was certified, and both sides filed a motion for summary judgment in the district court, claiming that they should win as a matter of law. The royalty owners did win as a matter of law in the district court and in the Court of Appeals under existing law. But this court, in the Fawcett 1 case, changed that law and held that neither party should win as a matter of law. On remand, plaintiff class sought to amend to conform the petition to the new law, but the district court refused, claiming that the Kansas Supreme Court mandate really intended to hold for OPIC as a matter of law. We're now back to this court to see if that's what the Kansas Supreme Court really intended, and if so, whether the plaintiff class gets an opportunity to prove its case under the new law. We start that issue with the amended petition conforming to the new law, and it can be done in two ways. One, if this mandate did not foreclose that opportunity to the class and rule in OPIC's favor as a matter of law, either express or implied, or the second is that intervening law occurred and the plaintiff class, under due process and fundamental fairness, should have an opportunity to replead and meet that new test.
Mr. Sharp,
Yes.
Is paragraph 6 of the district court's motion denying your request to amend the petition, is that paragraph correct? It says counsel for plaintiff admits today that in this case, a good faith argument requires a finding that OPIC can't sell the gas at the wellhead. Is that an accurate statement of what your position was?
No, I don't know if I would say it that way, Your Honor. Our position was that we could prove that the intended market was at the transmission line. We did say that the good faith of the midstream contract was undisputed. We said that, I think, in Fawcett 1, and we contend that still, that there is no good faith midstream contract issue. And then we did dispute the issue of the sale itself. So those were the three issues that were at issue before the district court and are still at issue to this court.
But was it your position that the mere act of selling the gas at the wellhead was also a breach of their duty of good faith?
That would have been an alternative pleading, Your Honor, if in fact this court did hold that as a matter of law, just putting in the title transfer clause in the midstream contract, that could be good faith as to between those two parties, but the royalty owners, of course, aren't party to that midstream contract. But we believe that would not comply with the duty of good faith as to the royalty owners, because the royalty owners are thrown under the bus by that particular clause. It does no benefit to the royalty owners, and it totally would benefit the OPIC and the EMP companies, because they would be able to foist those costs over onto the royalty owners if that was the sole issue. We don't believe it is the sole issue. We believe that the title transfer clause is simply a factor in how the defendant can prove that the wellhead sale was at the market and was a good faith sale. We don't believe that's dispositive. We don't believe the court found that dispositive. But in the unlikely event the court did find that dispositive as a matter of law, we would make the contention that the good faith and fair dealing, but also the implied duty to market mutual benefit rule would be violated by that. It simply splits the pie in a fashion where the royalty owners and the working interest owners are adverse to one another, and the working interest owners cannot split the pie against the royalty owners. We don't expect to have to proceed on that aspect of our case, Your Honor, because we believe that the mandate did not grant, as a matter of law, any kind of a ruling in favor of OPIC, and left this for a factual determination. There's never been a factual determination under the new law. Interestingly enough, there's really never been a trial to decide the disputed facts under the old law either. But under the new law, we believe that we have disputed facts, and that the trial court, should resolve those either with a jury or the trial itself before the court. So returning to the mandate itself, we don't believe that this court expressly reversed and rendered in favor of OPIC. And we don't believe that we don't believe the court really functions on an implied mandate process. We believe this court is, they say what they mean, and they never granted motion for summary judgment for OPIC. Given that, I won't go into it a lot, but the court did say what it means to be marketable remains an open question. And that open question is a fact issue when you allow that fact issue to exist. And you allow that fact issue to exist when the oil and gas lease is an implied duty to market lease. So we believe that the legal line was drawn in Fawcett 1, that the intended market good faith sale is that line. And we recognize that sometimes that line can go in favor of the EMP company at the well, but sometimes that line can also be at the transmission line. It all depends on the facts. If that is the case and the mandate does not preclude our case going forward, then the court need not consider the intervening law issue or anything else in this case. Simply remand the case back to the court, the trial court, reverse, and let us go forward proving our case. In the event that the court believes the mandate stands in our way, the court should look at the intervening new law and due process and fundamental fairness issue. And we contend that there are two new cases that involve the intervening law here. First, of course, Fawcett 1, that this court created intervening law from when our petition was first filed. The second, of course, would be Cooper-Clark, which simply explains Fawcett 1 under the circumstances of that particular case. It's notable that we do not ask this court to reconsider Fawcett 1 or to reconsider Cooper-Clark. just apply the law to the facts in this case and allow us, under due process and fundamental fairness, the opportunity to resolve those disputed facts in the trial court. The disputed facts are, and what is the intended market? OPIC claims the intended market is at the wellhead. I'm not sure exactly what their evidence will be of that, other than that they have a single sale transaction, but that usually does not make a market. A market is usually many willing buyers, many willing sellers, fungible products, and transparency, none of which exist at the wellhead, but at least that's plaintiff class's position. And the plaintiff class has always contended that the intended market is at the interstate pipeline. It's undisputed that that is in fact a market, and we believe it's the intended market if you look at the midstream gas contract and you look at the plant statements. Cooper Clark confirmed that what we always knew in Fawcett 1, that the concept of market could not be completely divorced from the marketable condition rule. The second issue of fact would be good faith of the midstream contract. As I indicated, that's still undisputed. And so there's no fact issue there. OPIC relies on it for its position, and we rely on those same midstream contracts for our position. The sale, however, is disputed. OPIC says it sells all of the gas at the wellhead based on its title transfer clause theory. Plaintiff class says that the sale is actually at the interstate pipeline where it's completed, because there's the risk of loss that occurs after the title is supposedly transferred, meaning the lost and unaccounted for gas. The subsequent cost, in fact, all of the cost of the midstream service contract is borne by OPIC after this title transfer. The pricing occurs at index and OPIC and at the OPIS for natural gas liquids, which is downstream of the title transfer. And of course, there's a force majeure clause included in the midstream contract in case they never reach the point of sale. So that intended market good faith sale should be, it's a disputed fact issue and should continue to go to the trial court and be resolved. I understand that OPIC believes we should be stopped from doing that. One, they claim that we won something below and that we should be stopped. We didn't win anything below. We won in the Court of Appeals, but we lost in the Kansas Supreme Court. So we shouldn't be stopped. But more importantly, we didn't make any changes to our position. The intended market, no change. We've always said interstate pipeline. Good faith of the midstream contract, no change. We still claim it's made in good faith between OPIC and the midstream providers. The sale, no change. We've always argued that completed sale was at the interstate pipeline. Now, granted, the Court of Appeals disagreed with our position on that, at least for determining what the two-pronged Walker lease was, whether it was proceeds or market value, but that's irrelevant. It's really irrelevant under the old law because both of those types of leases have the implied duty to market. So although the class did not cross appeal on that issue having won below, we certainly did not admit that fact. We still always contended that the sale, the completed sale, was at the interstate pipeline. So consequently, we believe we should have our day in court. The prejudgment interest issue, I think, has been adequately briefed. We think it's a simple issue to apply the textualism of monies due and withheld under KSA 16-201. That's exactly what we're saying here. The monies were due and withheld, and we had to sue to get the money. KSA 55-16-15 applies a floating interest rate, and its text applies to payments. In that particular case, it applies to late payments voluntarily made by the defendant. That's not the case that we have here, and it's not an advisory opinion. Last but not least, the class went to trial on the statute of limitations and the equitable estoppel issue, and properly proved its case. There's no reason to prove subjective intent when there's an affirmative misrepresentation, as there was in this case. And the reliance issue, there was substantial competent evidence on reliance, and this appellate court simply does not reweigh the evidence. Based on that, we would ask that the court conclude that the marketable condition rule is a question of fact when you have implied duty to market leases like we have in this case. that the prejudgment interest, when voluntarily but lately paid, would be controlled by KSA 55-16-15, otherwise due and withheld by KSA 16-201, and that the trial of the equitable estoppel issue should be affirmed.
Counsel, I have a quick question, although I admit to some trepidation in the question, just given the complexities of the issue. So feel free to correct me if this question misses the mark completely. But I guess it's this. Is your theory of the case that it is possible for OPIC to have not violated its implied duty to market, but somehow otherwise violated its implied duty of good faith?
I suppose those could, I'm sorry, I'm out of time. Am I allowed to go ahead and answer that?
I think the chief's nodding, yes.
Yeah.
Okay.
Sorry. Yes, please do.
Yes, I think the duty of good faith and fair dealing in that respect is almost identical to the implied duty for mutual benefit rule. And
Well,
so
isn't that again, as I understand it, isn't that what caused the lower courts here to rule against you? Because the lower courts basically said, look, the implied duty to market is entirely coextensive with the duty of good faith. And if that's true, then the royalty, your clients cannot prevail because this court has already said that OPIC met its implied duty to market, and therefore there's nothing left. At least that's how I read it. And I, again, admit that may be incorrect or oversimplified.
Well, that's not the way I read it, Your Honor. The way I read it was the first issue was all about the implied duty to market has three duties within it. One is the duty to get the best price, and that is the intended market best price for the gas products. And we don't contend that they did otherwise, because the gas contracts all show that they got index price at the interstate pipeline, and they got OPIS price for natural gas fractionated liquids. So they met the best price theory. The second piece of that implied duty to market is that they have to carry all of the costs to get the gas to the market and in a good faith sale. We contend that they didn't. They contend they did. That's a disputed fact. And that was the essence of Fawcett 1. What wasn't an issue in Fawcett 1, and this court, I think, expressly noted that was not in that issue in Fawcett 1, was the third element of the third duty under the implied duty to market, and that is the mutual benefit rule, which the court also mentioned. You could also put in the good faith and fair dealing duty with that implied duty for the mutual benefit rule. So those issues were never decided in Fawcett 1, and I think Fawcett 1 expressly said, if you think those are being violated, you can go back and
well, okay. So again, indulge me in possibly oversimplifying your case. You raised certain issues in the first lawsuit. When it all shook out, you lost. Then we went back and you said to the district court, hey, we've got some new issues based on the Supreme Court's opinion. We want to amend our petition to include those new issues, right?
That's correct, Your Honor. Although,
and so what was the new issue that you wanted to litigate?
Two new issues, actually. The first, when we lost as a matter of law that said we couldn't win the marketable condition rule being always at the interstate pipeline as a matter of law. That doesn't mean that we lose as a matter of fact. We often lose motions for summary judgment, and then we go to trial because there's disputed facts. So we wanted to litigate that issue, the disputed facts of the intended market good faith sale. The second part of what we said was, if we can't litigate that issue, the second piece of it is this implied duty under the mutual benefit rule or the good faith and fair dealing. That's the second piece of that implied duty to market that was never litigated in Fawcett 1, never raised in Fawcett 1. And the reason it was never raised in Fawcett 1 was because we didn't feel like we had that kind of a claim. We thought the claim was really a deduction claim.
why did OPIC not act in good faith? I'm just trying to get to brass tacks. Like, what is the actual claim here? Because
Yes.
the lower courts basically said, look, you are dressing up your old legal argument as a new fact-based argument. And frankly, it kind of sounds like that is what's happening to me.
Yeah,
So
that's
I'm
not
trying to
what,
drill into, like, are you saying there was some, I don't know, I can think of all kinds of way a duty of good faith could be breached. Maybe there was illegal kickbacks going on. Maybe
We
there was
don't allege that.
bribery. What is the argument?
Yeah, so we don't allege that, and this is pleading in the alternative, because our primary focus has always been, let's go back on the pure deduction case, because we believe we can show that the intended market was not at the well and the sale was not at the well, and the good faith issue between OPIC and the midstream company, that's not an issue. It's a good faith sale and a market sale between them. We like that midstream contract. The issue is not the good faith between OPIC and the midstream company, but the good faith between OPIC and the plaintiff. And that is governed by the oil and gas lease. And the oil and gas lease has the implied duty that says you can't subvert the royalty owner's interest to your own interest. That's what the mutual benefit rule is. So you can't use an affiliate to better yourself. You can't use, like you said, bribery or kickbacks to better yourself. By the same token, you can't use that clause if that's the only thing you've got, a title transfer clause, so that you can put all of those expenses over on the royalty owner. There's no benefit to the royalty owner to have that clause in the midstream contract. Of course, we're not party to that midstream contract, so we have no say on what goes in it and what doesn't. So what might be good faith as between those two parties is not necessarily good faith as to us.
And I know I'm taking a lot of time. I apologize.
I appreciate it, Your Honor. Thank you.
Circle all the way back to my first question. It sounds like what you just said is that, yes, in fact, OPIC might have fully satisfied its duty to market, but still violated its duty of good faith vis-a-vis your clients.
That's correct, Your Honor. It is possible that they could do the first one if we get those facts resolved. I must say that I don't think they can win that issue, but I also must say that in other courts, like in Colorado State Court, as well as in Oklahoma State Court, they have won those issues that the gas is in marketable condition at the well. They've also lost those issues because it's a fact issue. And we believe on these facts, they could lose that issue, and it's a disputed fact. The pleading in the alternative, we get to the good faith and mutual benefit rule issue. So you can actually put that aside, and we can just focus on the deduction issue itself. That's an issue which we believe is should be set for trial.
Your bottom line is that the transaction that OPEC negotiated for the sale of the gas at the wellhead should never have occurred. They had to sell the gas at the transmission point, not the wellhead. Or if they're going to sell at the wellhead, they can't deduct the costs.
Yeah, our position is that they actually did, in fact, enter into a contract to sell at the interstate pipeline. Their argument is, well, look at the contract. We have a title transfer clause in it. That's the only thing they have that says that there's a sale at the wellhead. That's the only thing. If you look at the whole rest of the contract and you don't elevate form over substance, then you're going to see that each one of those midstream contracts actually sell at the interstate pipeline. It's a disputed fact. If you look at that midstream contract, you can construe it either way. And if you look at the plant statements, I don't even think it's arguable. It's going to be completely that in our favor and completely against them, that there is no, there is no sale or market at the well.
So you're saying that the title transfer provision is the problem?
It could be the problem, Your Honor. It is a factor in the sale. There are many different issues on what is a sale. the bundle of sticks of what is a sale going back to our days in law school. Title transfer is one of them. Of course, gas is not a title transfer thing like a car or a real estate, but title transfer is one piece of that puzzle. The other part is, what about the risk of loss after that supposed title transfer? Well, that remains on OPIC. What about the subsequent cost? That remains on OPIC. What about the pricing? Does it occur there? No, it doesn't. It occurs downstream. What about force majeure clause for something that happens after? So-called, if you have title transferred and you're done with the product, why would you need a force majeure clause after you've transferred title and sold everything? So those are all just factors, and that's the reason there's a disputed fact as to where the sale is. The other piece of the puzzle, of course, is the intended market, and the intended market dovetails nicely with the duty to get the best price, and that best price is, of course, downstream, which is exactly what they got. That is the best price they got. And to get back to the wellhead, where there's really no pricing and no market, they use what's called net back pricing. They start at the actual intended market and they come back. Well, that's just further evidence that we have a disputed fact issue. They will contend otherwise. I expect my opposing counsel, who's very able, is going to argue just the opposite, and that's for a jury to decide.
Are there other questions?
If I may, Chief,
Justice Wall, please.
sorry, Justice Standridge. So I understand your sort of two-pronged theories on remand or on the motion to amend. I'm sorry. The first I understand is now a factual question on the intended market, where that is. I understand that argument, but when we delve into the alternative argument, did you allege in the amended petition all of these examples as the basis for the breach of the mutual benefit rule, that being the title transfer clause, the downstream costs, and the force majeure provisions? Are those all allegations that support a breach of that alternative duty?
That's correct, Your Honor. We also provided expert testimony, not only from a petroleum engineer, but also from a PhD economist who's an economist in energy economics to address what is a market and whether there is a market at the wellhead under these particular midstream contracts or there's not. That was an issue. The court didn't, of course, get onto that issue because the district court believed the mandate by itself precluded any further consideration.
Thank you.
My question is, if, as you're talking about, let's use as an example that you sell to OPIC for whatever price, and then the gas gets lost and OPIC loses all its money. How would that, I guess it's the force majeure, like something happens.
Correct.
And did your client still get paid?
It's our belief that if the gas doesn't actually get to the market sale point, that we don't get paid for it. And the gas contracts themselves will bear that out, because some of the gas is actually used in the process of going from the wellhead all the way to the interstate pipeline. It's used for compression, for running compression equipment. It's used for the processing plant itself. And if that gas, of course, doesn't actually get to the place where it can be sold, it's valued at zero and my clients don't get any money for it. Even though it came out of their well, as you can see looking at those plant statements, there's actual fuel that's used that never reaches the point. It goes through the gas meter, it goes past the title transfer, but we never get paid for it because it doesn't actually reach the interstate pipeline market where they sell the gas under that particular midstream contract. So the answer is yes, not only does the force majeure clause show it, but also the use of gas that's used before it reaches that market and that sale point.
Any other questions? Okay, thank you, Mr. Sharp. Mr. Corkindale?
May it please the court, Robert Kirkendall representing OPEC. This court's decision in this very case back in 2015 was a landmark decision that brought common sense back to the interpretation of oil and gas leases. This court simply held that when the oil and gas lease provides for royalty based on proceeds from gas sold at the well, a sale of gas at the well establishes the price of that gas for royalty purposes. Now, this holding might seem apparent, but some past courts' willingness to imply terms into oil and gas leases has created a field of implied covenants that seem to be ever expanding to provide royalty owners additional rights or protections. Ostensibly, this case is about whether the Court of Appeals correctly applied the mandate rule. In reality, this is nothing but a second attempt by the plaintiff class to change the terms of virtually every oil and gas lease in the state
Counsel.
by changing the implied covenants.
Counsel,
Yes,
can I jump in kind of with where we left off?
yes.
What would happen if the sale at the wellhead was a sham? It was a sham in intention. Let's say, and I know this isn't our case, but let's say you had, solid evidence that it was a sham, phone recordings that, we're gonna rip off our royalty holders and we're gonna enter into this sham deal. But the marketability rule would suggest that, hey, we met the marketability because we made a sale. Would the royalty owners be able to bring a breach of good faith claim at that point?
Yes, Your Honor, I think that somebody could bring a breach
And why
of good
isn't
faith.
that exactly what these royalty owners are trying to do? Admittedly, in a much more factually contested way.
Well, in the first Fawcett decision, this court did provide that if the contract for the sale of the gas was not entered into in good faith, such as in your example, then there could be a claim for.
Well, because in my hypothetical, you've got two bad actors making a fake transaction.
Correct.
But they're acting in good faith vis-a-vis one another. The party that they're trying to defraud, the royalty owners, isn't a party to the contract.
Well, Your Honor, you said in Fawcett 1 that a bad faith contract, such as between the seller and the marketer, where the purpose of that contract is nefarious, to cheat the royalty owners, then that is subject to review by the courts. And certainly that is not the case here.
I understand that you've got probably all kinds of evidence that you would present to a jury to say, that's not what's happening at all. We're not trying to cheat the royalty owners. I'm just asking, it seems, I guess I'm struggling with understanding why the royalty owners can't make that claim. If they think they have evidence to back that up, why can't they make that claim? And why does Fawcett 1 prohibit them from making that claim?
Well, first, Fawcett 1 prohibits them by virtue of the mandate rule, where Mr. Sharp and the class agreed that there was no evidence and there was no claim that that contract was in bad faith in any way. They can't now change position on remand and say, oh, yeah, we're going to claim that it wasn't bad faith. And their argument about bad faith is not simply that this particular contract or one particular contract was in bad faith. Their claim is that you cannot sell gas in Kansas at the well without being in breach of this obligation of good faith. Now, that argument virtually strips the first Fawcett decision of any vitality at all. And it would completely eliminate what this court's holding was the first time around. This court held that when a lease provision provides for royalties based on a share of proceeds from the sale of gas at the well, and if the gas is sold at the well, then the duty of the operator to bear any expense stops.
Is it fair to say then that, and again, I keep coming back to my initial question, which is me trying to make this as simple in my own mind as I can. Your answer would be the opposite of Mr. Sharp's to my initial question, which is, I think you would say that once the operator has met its duty of marketability, then it has also satisfied its duty of good faith, because the two go hand in hand.
Absolutely. In this particular case, yes, where you're suing for these additional royalties based upon something that happens beyond the point of sale. And yeah, you cannot square Mr. Sharp's argument about the duty of good faith with the holding of Fawcett 1. And both of the courts below held that, and they correctly held that. I do want to...
Counsel, can
Yes.
you help me then walking through the factual averments in the proposed amendment to the pleadings? Why, as a matter of fact, doesn't the intended market of or the party's intended market matter, or does it matter? As a fact question, not...
Well,
does that make sense?
The quote intended market argument reached this case when Mr. Sharp filed his petition for review of the Court of Appeals case. The intended market was never an issue before that point because the Court of Appeals hadn't decided the Cooper-Clark decision. So this notion that the intended market is someplace else never was present in the case. What was present was an argument that you could not have a market and gas could not be marketed at the well because you only have a contract between a single purchaser and a single seller. In fact, we have multiple contracts involved in this case between multiple purchasers and the seller in different wells. And they all are not the same. They all are somewhat different. The prices that they reach are different. But we know that those were all negotiated and entered into good faith.
Let's just say that hypothetically, the amended petition was the original action. Do those averments on the party's intended market, if we assume them to be true for purposes of the pleading, state a viable cause of action post Fawcett?
I don't believe so. I don't believe so because, again, what they're talking about is the duty to market the gas. And this court in Fawcett held that OPIC had satisfied its duty to market the gas by entering into a contract for the sale of gas at the well and basing royalties on the price that they received for that gas at the well. I just don't see how you can avoid that specific holding in this case based upon the mandate of the court and what the court said in its opinion. I do want to briefly address the question of the interest rate. That does seek an advisory opinion by this court because the court below did not award any prejudgment interest, whether under the interest rate statute or the prejudgment interest rate statute, because it was unable to determine when any claim was liquidated. There were reasons for that. And of course, those reasons are not subject to review because they aren't even presented. We think that applying the interest rate statute, which applies to, quote, any payment of royalties made late, was appropriate. But in this case, awarding no interest was even better because the plaintiff class failed to show what it needed to in order to allow the court to make that determination. I do want to turn to OPIC's cross appeal in this case. And we are cross appealing the treatment of the doctrine of equitable estoppel that tolls the statute of limitation, or in this case, eliminates the statute of limitation. Now, equitable estoppel has three parts, and these parts can generally be found in virtually every additional royalty class action case out there. The first is the statement by the defendant. The second is reasonable reliance to the detriment by the plaintiff. And the third is an attempt by the defendant to deny the statement of fact. You know, in royalty class actions, they all seem to stack up the same way. The statement of fact is the check stub. The misrepresentation in the check stub is the fact that payment doesn't comply with whatever it is that the plaintiff class contends should have been in it. In this case, OPIC added the conservation fee assessed by the KCC to the state taxes and included that in the deduction there without expressly stating it. In other cases, it is not showing deductions for processing or compression or treating or otherwise. So in every case, the misrepresentation is a statement in the check stub. So in every royalty case, you're going to have that prong satisfied as the Court of Appeals and as the district court held was required. The second one is reliance on that statement. And you're going to have two claims of reliance in virtually every class action case. The first is the royalty owners cashed their royalty checks. They took the money. Of course, we've always contended that that is not a detrimental reliance, since the royalty owners were in no worse position having taken the money than they would be had they refused the money. The second act of reliance is not filing the case sooner. And of course, that really has nothing to do with the representation stated in the check stub. If you look at that as an act of representation, then you conflate equitable estoppel with the doctrine of reliance. And you get there without having ever to prove an intentional misrepresentation or something along those lines. The Court of Appeals stated that the check stub induced royalty owners to believe the conservation fee was a tax. Now, how it did that by not talking at all about conservation fee is kind of a question, and whether the conservation fee was a fee or a tax really doesn't seem to be a representation of fact that should induce action to not resolve the issue. Now, if that was a question of fact, if there was reasonable reliance, OPIC contends that that reasonable reliance needs to be shown for more than simply one class representative. Reasonable reliance should be told only for those class members that actually did do detrimental reliance. And in this case, the only way you can get there is by converting this reasonable reliance into some kind of a discovery rule. And that is exactly what the Court of Appeals did. Now, some class members who did know either that conservation fees were being treated routinely by everyone as part of taxes prior to Fawcett, they still got the money. They still were, or OPIC was still prevented from asserting any kind of statute of limitation against those people. Finally, the third requirement on what makes estoppel an estoppel is the requirement that the defendant who asserts a question of fact or a statement of fact be unable to change that statement of fact. That's what makes estoppel an estoppel. How does that apply in this case? Are we prevented from changing anything on the check stub, which was the misrepresentation? No, the plaintiff class wants us to change how royalty was computed and to redo what was shown on this statement. In royalty owner class action cases, this third part, the estoppel part, is eliminated. And all that results is that the defendant is stripped of the statute of limitation case. We aren't prevented from stating anything. There is this claim that we lulled royalty owners into an action, and because of this, we cannot assert the statute of limitation. But as equitable estoppel, we are not being stopped from asserting or from changing a position we took prior. We believe that this court should put the estoppel back into the doctrine of equitable estoppel and overturn how that doctrine was applied in this royalty owner cases, and by extension, in virtually every other royalty owner case out there. Now, for these reasons, OPIC would request the court affirm the lower court's holdings with regard to their interpretation of this court's mandate, the decision on the prejudgment interest, which was not to award any at all, and reverse the lower court's determination and direct judgment be entered in favor of OPIC for the claims that were barred by the statute of limitation. In other words, cut off that first decade of damages that the plaintiff class were able to recover.
Counsel, I
Yes.
have again a sort of big picture question just to help me understand all of these relationships. Can you, in simple terms, describe for me the economic rationale for why the producer chose these economic arrangements?
Yes, absolutely. Producers are in the business of producing gas. They're in the business of exploring wells and operating wells. They do not get into the area of midstream, of laying pipeline, of doing all that. That is a separate operation. So just for convenience and just because of the economics, they don't want to become a midstream company. They want to confine their actions to what happens on the well and related sales.
And so after the gas went to the midstream folks, did it come back to your clients?
No. We make the sale at the wellhead. The risk of loss happens at the wellhead. What they do with the gas after that point is completely up to the midstream company. We don't have anything to do with it at that point. What happens is that we base our price that we receive for the gas that we sell at the well on something else. It's because the price of gas is so dynamic. We need to tie that price to what's happening in the market.
So if I understand that rightly, this is actually economically rational because by selling at the wellhead, you do forego the possibility of greater profits in its finished state. In other words, at the downstream pipeline, but you also are getting rid of added risk of having to spend more money than you can recoup in the final sale downstream. Is that a
Sure. The midstream process is very capital intensive. You've got to lay pipeline, you've got to have a processing plant, you've got to have economies of scale, and all of those are beyond the ability of typical producers to do. So essentially selling the gas at the wellhead, giving all the risk to a midstream company who can then maximize whatever it wants to do with the gas is a rational way to organize the industry.
Okay.
Now, OPEC needs to tie its price to something else because the price is very variable with gas. And the common way to do that is to pick a price down the stream and then adjust that price to reflect a value at the wellhead. And that is what is done in all these various different contracts, whether it is simply starting with an index price and we receive 85% of that, or whether it's more complex, where we get a share of liquids extracted. They're all different terms on that, but the whole purpose is to enable the seller to produce or to obtain a price that fluctuates wildly over time.
Counsel, does that calculation take into consideration the fact that some of the product may be used during the midstream and therefore, such as in the equipment, as Mr. Sharp said?
Well, Your Honor, the price is adjusted so that we are compensated based on everything that is produced. Now, whether one of those adjustments might be some adjustment for gas that is lost, that is possible. But we are paid at the well for gas that is produced. And contrary to what Mr. Sharp says, we aren't paid for a lesser amount of gas down the end. We are paid for what is produced at the well.
And I also understand that the producer isn't paid any money that isn't also paid to the royalty owners based on their percentages. I mean, in other words, you sell the gas at the well. You get paid based on this complicated formula for the gas at the well. Those expenses are included in that, but everybody shares in those expenses, and you get, a higher price at the well than you might if you sold it through some other formula. But you're not getting any extra money.
We aren't getting any extra money. We are getting the best price that we can possibly negotiate for the gas sale at the well.
And
This
the
is in our
royalty owners share in the best price you're able to get.
absolutely. And
But what they're arguing is that you're not legally allowed to deduct those expenses.
absolutely.
And
It's-
that's what was resolved in Fawcett 1.
That is our understanding, Your Honor.
Counsel, was the fairness of the expenses settled in Fawcett 1?
Your Honor, I believe that the question of who should share in those expenses was
Correct.
addressed in Fawcett 1. And that was addressed by the court saying, a sale at the well, if it's in good faith, is the stopping point. And at that point, expenses incurred by someone else later in the process are not OPEC's responsibility.
I didn't articulate that very well. Was the amount of the expenses assessed to the royalty owners in that contract, was that determined in Fawcett 1?
Your Honor, I don't believe so. Because again, what you're talking about is the amount of the expenses incurred by others in the process. What is important and what is really of concern to the royalty owner is the price received at the well and whether that price is the best price that a producer could get, whether that price complies with the duty to the duty to market. And where that contract and that price satisfies the good faith duty to market, then, that's all that the royalty owner could reasonably expect.
And is it true then that the expenses that will be incurred after the wellhead sale, those aren't expenses that you share in, correct?
Correct, absolutely correct.
After the sale, the gas is gone. It's none of your business anymore, right?
Correct.
And so do those post-sale expenses, is that part of the formula that determines the price of the sale at the wellhead?
They may influence the price. They may influence the price at the wellhead, yes, because midstream companies are not going to pay as much for gas that is of lower quality.
Yeah, dirty gas
Lower
costs
processing.
more to put it into a saleable condition than clean gas. And those may not be industry words. That's just how I think it.
Yes.
So if the person the entity that's buying the gas has to spend more money to make the gas saleable to the end user, that would impact. I can understand how that impacts the fair market value of the gas at the wellhead. But what I'm asking is slightly different. Is there some formula that is used to create a wellhead transaction price that sort of incorporates those downstream actions?
Yes, typically a lot of the midstream company is hedging their economics as along with everybody else, and they will base the price they're willing to pay upon what they can receive for their products and their expected costs. And the formula typically kind of is a combination of all of those things. Although in some cases, it is something as simple as 85% of an index price, and that's it.
And from your client's perspective, there's no economic reason why you would care about that. You don't
Correct.
care how they came to their offer. They're making an offer for your gas.
They're wanting our gas.
You
and
just
we're
care
selling
about
it
how
to
much
them.
they're offering, and you're trying to get the best price.
We're trying to get the best price. That's
Okay.
what we're after.
Justice Standridge, you're muted.
Sorry, I was trying to use the space. So I have a question. It appears as if the royalty owners are making a big distinction here between the contract they have with OPIC and the distinction of the OPIC contract with the processor or whoever gets it to the end market. So in the contract between the royalty owners and OPIC, where I think now they're saying that's where their bad faith claim is, or not in good faith. What is it part of the deal? Is it mentioned in there about the expenses being deducted later?
There are very few oil and gas leases out there that talk specifically about deducting expenses. What this case talks about is it requires, most of the leases at issue in this case require that if the gas is sold at the well, then royalties are based on proceeds received from that sale. So that is the obligation that we believe applies to OPIC in this case. We sell it for the best price we can, and we split the royalties according to the lease contract.
Thank you.
Are there other questions? Justice Wall?
Just one more question, counsel. But after Cooper Clark, if a party alleges that the intended market was interstate market, that's not foreclosed by Fawcett 1, correct?
Well, Your Honor, I have a whole lot of problem with this notion of intended market. Whose intent is this market? You know, where does that enter into the issue at all? You know, for OPIC, it doesn't care where the market is. It sells at the well for the best price it can receive. And what happens to it after that is somebody else's problem.
Well, then how do you interpret the holding in Cooper Clark?
I would say that the intended market argument in Cooper Clark was just another way of saying that Cooper Clark is distinguishable from Fawcett because the gas in Cooper Clark was sold at the tailgate of the plant and not on the well, or not at the well, on the lease. And the intended market is just language that was a little loose and became part of the opinion.
Any other questions? Thank you, counsel. Mr. Sharp?
Thank you, Your Honor. I'll try to be brief. Let me begin with the argument that was made that we're trying to change the oil and gas leases. We're not. We tried to do that in Fawcett 1, both sides tried to. There are 3 types of leases. There's an express deduction lease, one that is negotiated between the parties and expressly says you can deduct midstream service costs. We don't have any of those here. There's a second kind that expressly says you can't. It's called express no deduction. And both of us, both the E&P companies and the royalty owners, are always trying to get the implied duty to market that's silent on whether deductions can be made to get closer to the ED or closer to the express no deduction angle. And we both tried to do that by filing our motions for summary judgment as a matter of law that would get us there. In other words, take all of these implied duty to market leases and make them express deduction leases. That's what the industry wants to do. Or make them express no deduction leases. That's what the royalty owners want to do. But this court in Fawcett 1 said pox on both your houses. Implied duty to market leases are silent as to deductions. That's a gray area, and you're going to have to prove it factually. It's an open question. It's a fact question. It doesn't say you can change a proceeds lease. As you heard them talk about, their midstream contracts are sometimes percentage of proceeds, like 85% of the proceeds. How in the world can a proceeds lease be considered that you're going to get 1/8 of the proceeds, and then all of a sudden, based on their contract they enter into, you get 1/8 of 85% of the proceeds? That's not what the lease says. There's no way that you can construe it in that manner. So let's take a look at this fiction of that there's a market at the well. There is no market at the well. You never heard him describe that there's a market at the well. You always heard him describe, we're trying to get to the market where there's actual gas products sold, and we will net back the cost of services. Let's take a look at midstream contracts throughout the country and throughout Kansas in particular. There are 3 main types. One is a fee contract. This is a classic, we will take your gas at the well, and for the services fees that you're going to provide us, we will service and clean up your gas and get it to the actual market. You will pay us those fees, and we will pay you what you receive for the gas products. Those gas products are methane, ethane, propane, butane, and pentane. That's what you get. That's what you receive. And that's what the proceeds would be, 100% of all of that. But if they do that, then they have to come out of pocket and pay for those services. Because after all, these midstream providers, they are not buying and selling gas at the well. They are merely servicing and cleaning up that gas so it can actually get to the market at the interstate pipeline. That's what all of these midstream contracts provide. I will say there are contracts that provide for sale at the well. They're called irrigation gas sales, and they were reflected in the Cooper-Clark case as only about 1%. So that's the reason the intended market is still part of the marketable condition rule. It is called the marketable condition rule, not just the saleable condition rule that you can title transfer it anywhere in a gas contract and call that good enough. You have to get it to a market. And that's not only the law in Kansas that the Cooper-Clark case picked up, but it's been the law for many, many years.
Counsel,
Yes,
are you, again, I'm just trying to understand the economics of this.
sure.
Are you saying that the operator retained an interest in the gas in this case?
Absolutely. It contractually retained an interest in
Well,
the
because
gas.
when I was talking to your co-counsel, at least what I heard, not your co-counsel, your opposing counsel, what I heard was, hey, once we sell it, it's out of our hands and it's gone. We have nothing more to do with it. So I want to pose a hypothetical. If between the time the transaction at the wellhead happened and the transaction with the ultimate end user buyer, let's just say that the gas market went crazy and 10x'd in price. Does OPIC benefit from that under these contractual agreements that exist in this case?
Only if the gas actually gets to the place where it can be sold for 10x. So
but you're saying that OPIC retains a financial interest in that gas.
Absolutely.
Can
They
you?
do.
Okay. And that seems to me to be an important fact, whether it's true or not.
It is an important fact, and it's set forth in the midstream contracts. The
Yeah,
midstream contracts.
But wait a
Yes.
minute here. The money that OPIC receives, they share with you, regardless of whether it's higher or lower. They don't get a bonus somewhere along the line.
That's not true.
Okay.
That's not what happens. They do not pay us for the gas products that they receive the market price for, where they sell it. They do not do that. They take deductions from that price all the way back to the wellhead so that we end up being their silent partner as if we were owing all of those midstream costs, all those midstream service costs. So in fact, in every one of these midstream contracts, OPIC receives the index price for methane, and it receives the oil producers' information service cost for ethane, propane, butane, et cetera. That's what they receive under the contract. But then they have to pay the midstream service costs because that's what the contract provides.
Yeah, I want to get back to this. I really think you're changing horses here in your case because the Fawcett one was built on a summary judgment by both sides, stipulated facts. We know what the lease says, and the leases, there were 25 of them. You guys stipulated that there were two general forms. Both allow for the sale of the gas to pay the royalty based on the proceeds from the sale of the gas at the mouth of the well. And you made no complaint about OPEC's contracts with the third-party purchasers, which deducted all that and generated the proceeds. You just said the word proceeds in the lease does not allow those deductions. And that's what you lost on. So I don't understand how you can come back now and say, oh, I mean, you're almost saying Fawcett 1, the premise of Fawcett 1 was all wrong because you had other allegations out there.
No, we did not have other allegations. Fawcett 1 was based on the physical condition of gas. We won, and we would have continued to win until Fawcett 1 changed the law. It changed the law from a physical condition of the gas to a market sale condition or a market sale theory. That market sale theory was never litigated in Fawcett 1. We won on the condition and quality of the gas. This court said, no, you're applying the wrong standard and test. Remember, even my opposing counsel said Fawcett 1 was a landmark decision. It was. It changed the law. Instead of looking at the physical condition, we're now supposed to look at the intended market and good faith sale. When we look at that, that's not something that was ever pled in Fawcett 1, so we couldn't have litigated that issue. We're now going back to try to litigate that issue. That intended market, a little bit, it's very prescient of this particular court to look at changing that, because that's what the federal law has done for marketable condition rule. In Watson versus Amico, Justice Roberts had that same kind of concept of market and sale are not synonymous. You have to get to the sale at the market, not just sell. Same thing happened in Burlington Resources versus Department of Interior. And this court picked up on that and changed that so that we could focus on the contracts and focus on the market and sale rather than on the physical condition of the gas. And so given that, neither one of us won as a matter of law, and we're now going to go back and look at the facts. Can we show an intended market? You heard from my opposing counsel, he says there's an intended market at the well. There isn't, we don't think so, but that's a disputed fact. He's got arguments, I've got arguments. He's going to put on facts, I'm going to put on facts. That's okay. Sometimes we'll win those, sometimes we'll lose those. That's the nature of what happens when you leave a gray area in the contract. So we would ask this court to say that the mandate said nobody wins as a matter of law. When you've got implied duty to market leases like you do in this case, you're going to have to prove your case on the facts, and we set the new standard. And that new standard, whether it's the mandate or whether it's an intervening law, that new standard is intended market, good faith sale. If you can meet that test, great. If you can't, you lose.
You're out of time, so that's why I was interrupting. I'm sorry for that.
I appreciate that.
Ask another quick question about is OPIC getting paid twice for the gas, once at the wellhead and then once after the final sale?
OPIC receives the value of the gas products, the marketable gas products, and then it has deducted from that, contractually deducted, the cost of services.
But that's at the wellhead, right?
Correct. They all the way back to the wellhead because the gas service provider provides services all the way from the wellhead.
Is that purchase price calculated at the wellhead, or is it calculated after the final sale?
The purchase price in this particular case, or the purchase price is only at the market because that's where gas can be sold.
Well,
there's no price.
Okay,
raw gas. There's a difference between raw gas and gas products that can be sold.
I understand that, but I'm trying to figure out, when does OPIC get paid? And because there's gas at the wellhead, and then it gets improved, and presumably that takes some time, and it gets transported to the final purchaser. And so I understand OPIC's argument to be, look, we're getting paid at the wellhead.
They in fact do contract to say, we will get paid the gas product, and we've contractually agreed with you to pay you for the services. You can deduct that from the product, but the oil and gas leases in this case are silent about paying anything for services.
I'm just trying to understand what actually happens.
Yeah. So
if the gas is sold for $100,
right,
at the downstream, is OPIC's take of that $100 determined then, or is it a flat $50 at the wellhead?
It's a formula for paying for the services. They do not pay royalties on the $100 proceeds they get for the product. They pay for the $50 that they get at the inlet to the plant. Does that help? It's a net.
No, not really. I think we're talking past each other. I'm trying to understand what happens if the price of gas triples between the time it's pumped at the wellhead and it's sold downstream? Who benefits from that tripling? My understanding is OPIC's saying we don't benefit at all from that.
Oh,
The
yeah,
people who benefit from that are the midstream producers, not
No.
us, because we already sold it.
yeah, OPIC would get them $300 for the gas product when they sold it, because that would reach the sale point when the price tripled. But they would then have to pay something. I don't know whether it wouldn't be a flat $50 for the services. It would probably be an escalator price, more like $75. So bottom line is they would get more money.
And your point is, look, they're not actually marketing at the well. This is just an arrangement to make it look like they're marketing at the well. What they're really doing is marketing it to the end consumer.
I wish I had said that, Your Honor. You're correct.
Any other questions? Thank you to both counsel for your arguments. We will take this appeal under